We're recording. We are deliberating CBA 23-017, Anna and Leo Kutin, 12726 Gores Mill Road. This is a request for a variance from a forest conservation easement pursuant to BCC section 33-6-116, requesting a 4,250 square feet incursion into the forest conservation easement for a fire pit and a patio that's already been constructed. We heard testimony from the petitioners. We also heard testimony from Maria Brady from the county, who was sort of the expert on the situation. This is an interesting procedural situation because this is where we have the actual denial of an easement, and the county was here representing the other side rather than protestants and things of that sort. We heard testimony that there was, I guess, a fire barrel or some sort of barrel used for burning things that was present on the property long ago, and that the homeowners had cleaned it up, replaced it with what is there now, and kind of built a much more elaborate fire pit situation. There was also some photographs and testimony about some other disturbances on the property that I didn't really get into because I wasn't clear whether that had occurred before the subdivision of the property, which actually brought this code section into light anyhow. Meaning when the property was subdivided, there was county folks out on the property who then located what they saw it to be an incursion into the forest conservation easement, and then here we are. So this wasn't really a neighbor complaint. This was just happenstance of what occurred when the property was subdivided. Looking into the statutory requirements that we're to look through, this isn't like a regular Cromwell variance. This is in 33-6-116. We actually make specific findings under subsection D in order to find what's called an unwarranted hardship that would allow relief in this situation. We have number one, that the land in question couldn't yield a reasonable term if the requirement from which the special variance is requested is imposed and will deprive the applicant of all beneficial use of the property. Number two, the plight of the applicant is due to unique circumstances and not general conditions in the neighborhood. And number three, the special variance request will not alter the essential character of the neighborhood. There's additional findings dealing with water quality, and an important one in E2, that the special variance does not arise from a condition or circumstance in which the result of the actions taken by the applicant. So that's basically the law that we're dealing with in this situation. I believe the testimony that we heard from the homeowner was they've made a nice place to be back there. His grandchildren use it. There was already a fire pit there. I think Mr. Evans kind of asked some questions in investigation about the history of, that fire pit and how it's changed and what it was used for. And also there were some questions by the board looking at the aerial maps of the area, wondering, the different places on the property that perhaps could have the fire pit. I think the testimony of the homeowner was basically mostly about appearances, that it just wouldn't look right if it was out front or somewhere else other than where it is. So that seems to be our charge, to determine through the statutory mandates of 33-6-116 whether or not a special variance is warranted in this situation. And I open the floor to my colleagues. Anybody want to speak first? All right, well, I'll speak first. My thought on this matter is this: I believe that the homeowner has best intentions. I believe that the area that has been constructed wasn't done in a manner to violate the statute, and it was done before the subdivision, evidently, that brought it into question. What concerns me, though, is that I understand the presence of the fire pit that has always been there, but what's being requested is 4,250 square feet. That disturbance, as we saw from the photographs, really encompasses the very elaborate patio situation that surrounds the fire pit. And that's a pretty big chunk. And then looking at, well, like I said, in the subsection of the code that deals with whether or not the problem and need for the relief was due to, the actions of the homeowner themselves, I think that kind of clearly falls under that part of the statutory consideration. As for character of the neighborhood, I don't think it's any problems with the character of the neighborhood. But we're dealing with the law, and the law is pretty clear about whether or not you can go into this forest conservation easement. So that's where I am right now. If it was just the fire pit itself, that maybe I might be more swayed, or I don't know if we can come up with some sort of decision that could allow for that. But I think the whole 4,250 square feet is somewhat unwarranted in light of the conditions. So, any thoughts based on my thoughts?
Well, I'm not convinced that the fire pit predated the subdivision. I'm not convinced of that. I mean, Ms. Brady testified about what happens during the subdivision and what things are noted, and she indicated that that fire pit wasn't noted. There was an absence of a record of it. That's probative, seems to me. So I'm not convinced that it predated the subdivision. And I'm not sure it matters, but I'm not, as I said, I'm not convinced of it. I generally have, I generally don't want our government to tyrannize the citizens over minutia. And Mr. Kutin seemed like a pretty nice guy. And it seemed like, all things considered, it seemed pretty inoffensive. But I must say that as I listened to the testimony from Ms. Brady, I found it pretty compelling. And I don't think this is minutia, actually. Mr. Kutin testified that he now sees more wildlife than he did before he did all the clearing. And Ms. Brady indicated, and I thought this was rather interesting, that's misleading. Okay, what you see, or you see animals, or you see wildlife that can function where there's clearing, but what you don't see, what's eliminated is all the natural habitats and all the widely diverse bio life forms that are there when it's in its natural condition. So at the end of the day, I mean, I don't think Mr. Kutin, I thought he was engaging and likable. I really do, and I would like to be able to rule in his favor, but I feel like the law and the equities actually probably, the law certainly, and the equities probably go in the county's favor.
I too had concern about the history, and I know that there was an attempt to find record of the fire pit. I tend to believe it may have existed, and it may not have been recorded because of the prior use of that fire pit. But now how it's being used is much different than it had been historically. So I did think that that was something that needed to be taken into consideration. And I do have concern about the wildlife impact and the testimony that was given in that area. There wasn't any expert testimony given by um, Mr. Putin. So I too give a lot of weight to Ms. Brady here. And the other was when you're looking at when you do grant the variance, I was trying to see, is this unique in some way because of the history of the fire pit and not necessarily persuaded there. I don't think it's an unwarranted hardship if it wasn't granted. I know that for the family and their personal use that um, it's not wanted, but I don't know if it's an unwarranted hardship. I was leaning toward you, Mr. Belt. Was there potentially some way um, to meet somewhere in the middle? Only because, as you mentioned, Mr. Evans, I do have some concern about the county this later being discovered. This may have been here for some period of time, and now um, because of the subdivision, and the subdivision is by the Putin, that now this was discovered, and um, what impact that has on them personally. I don't know what we that is somewhat of a compromise. Have you given any thought to that, Mr. Belt?
My concern with the compromise situation is that we will be back. Because say if we were allowed the fire pit to remain, there's going to be gradual possible, I don't know, things added to it, or the disturbance is going to be there nonetheless. And I don't know, it's not like we have a ruler that we can do virtually to find out the square footage that would be allowed. And then that could be a very elastic standard about how big actually the fire pit is. So I don't know. That's sometimes the best of intentions causes bigger problems because of the gray area that's there. So I don't know. I was on board with the fire pit until I saw the pictures of the elaborate nature of what was going on in conjunction with it. And that was, I mean, then I understood where the 4,250 square feet came from. So I just, I don't know. And Mr. Evans brought up a good point, and it's a point that I guess a regular, lay folks don't understand what seems to be messy and needed to be cleared away is the type of forest undergrowth really that is protected by the forest conservation easement. That's it's not really aesthetically pleasing sometimes because it just looks like a mess. But I understand from what Mr. Kutin said, he was cleaning up construction materials and all kinds of other things that had been dumped or whatever. That's a different story. But the wild, when the overgrowth or undergrowth takes over, that's pretty much the intention of what's supposed to be done. I think Ms. Brady let us know that as well. So it would be difficult to allow those conditions to take place around a fire pit. It's almost counterintuitive. There had been some discussions of a previous fire. I saw no direct nexus between this fire pit and the fire. So I don't want anyone to think that I think that they started a fire. But in the true sense of the conservation easement, if we were to let nature take over that area, but for a fire pit, we might be putting a fire pit in the middle of kindling, which again comes back to how do we police that going down the road? Well, not us, someone will, and then it might end up in front of code enforcement or someone else. So I don't know, that's sort of talking in circles, but I think that's things we have to consider.
I don't agree that that's talking in circles. I think you made two incredibly excellent points. Number one, the wild growth doesn't always necessarily harmonize with our imperative to make things neat, which is an interesting. I've listened to some podcasts about how evolution, biological evolution, plays into wanting neatness, but that's a different issue. But also, and I share your view on the. I don't think the history of fires. That doesn't enter into my calculus here at all in terms of the fire pit causing fires or anything like that. But if it is left to be uncontrolled all around the fire pit, it does become kindling, I think, and that then becomes a problem. So I agree with both of those points, actually.
Same here, and as you said, Mr. Evans, the law is the law. And so, based on the conversation that we had here, then I would say that we haven't met conditions to grant.
And the final point is, one of the factors is whether or not, basically the translation is if you don't grant the easement, then they won't have a return on the property. It was kind of because they were able to get a return on a subdivision that this was brought to light. It's kind of like the give and take. But for the subdividing of the property, this really wouldn't have come to light. But when you subdivide the property, it brings it up to, the current laws and regulations dealing, with such forest conservation easements. So the microscope comes and looks because you've availed yourself to the subdivision. I know it's a hard pill. I'm not saying it's deserved, but it's just the law. And as Mr. Evans said, our sympathies are with Mr. Kutin, who presented as an individual has all but best intentions for his family and for his property. And I would agree with him. He's made a very attractive place to be, but unfortunately us, we have to apply this law thing, and the law's pretty clear. So I think our hands are tied when we apply the facts of this case to the statutory requirements for the granting of such a special variance. So,
well, I mean, his property is alienable with or without a fire pit. I mean,
oh yeah, it's still a beautiful.
It's a beautiful piece of property, and he hasn't lost any appreciable amount, or he doesn't lose any appreciable amount of value by the elimination of this fire pit. So
yes,
you know.
All right, but I guess again, I understand why he wanted to keep it. So there's that. Yeah.
Yeah.
All right. Well, based on that, then I guess we are unanimous in that regard. And I think I'm due. I'll volunteer to write this one because Joe, our last deliberation, you volunteered on that one. So I'll make sure that I volunteer for this one.
Oh, thank you.
All right. All right. Everyone have a lovely day.
Okay. Thanks a lot. Yeah. Bye. See you, Sharon.